This is usually followed by statements by ministers, questions and answers to questions, items on the government business and private members' motions. On the agenda, under government business, the Political Parties Registration Regulations 2017 resolution under the Representation of the People Act is down to be debated. The bill contains regulations relating to, among other things, procedures and registration of political parties intending to contest the poll in parliamentary elections, parish council and Kingston and St. Andrew Corporation elections, and municipal elections. Also included are procedures for refusal of and objection to applications for registration, proceedings for the deregistration of registered political parties, procedure for application for state funding, obligations of registered political parties that qualify for state funding, use of state funding by political parties, financial reporting requirements for political parties, and more. The House is scheduled to continue debate on the bill entitled An Act to Amend the Companies Act. The amendment is being piloted by Industry and Commerce Minister Carl Samuda. According to the minister, the bill seeks to amend the Companies Act to ensure that it provides to conform with the international obligations in respect of transparency, accountability, and good governance. It will also provide information in relation to beneficial workers which should be made available for the public record. In addition, the bill will require foreign companies having their central management in Jamaica to maintain ownership information, and it will also require the provision of information on holders of share warrants and prohibit the insurance of these share warrants. Other amendments will address maintenance of records and compliance with international tax laws. And that's what's on the agenda. It should be noted that elements of the day's agenda can be changed or moved. But before we go, here are a few things you need to bear in mind if you plan to attend a session at Gordon House. No visitor shall create any act of disorder within the precincts of the House. No visitor shall be admitted to the House without first obtaining an admission card from the office of the clerk. Visitors who remain within the precincts of the House during a suspension of the session are asked to keep silent. No photography, videography, or sketching of the proceedings is allowed, unless so authorized by the presiding officer. And there should be no smoking inside the parliamentary building. Now over to the proceedings.
Ms. Daly, Mr. Daly, Mrs. Dalrymple Philibert, Dr. Davies, Mr. Fagan, Dr. Ferguson, Dr. Green, Dr. Guy, Ms. Hannah, Mr. Hales, Mrs. Holness, Mr. Hilton, Mr. Jackson, Mr. Kellier, Mr. Main, Dr. McNeil, Ms. Nita, Mr. Paulwell, Mr. Michael Phillips, Dr. Phillips, Mr. Pickersgill, Mr. Redmond, Mr. Robertson, Mr. Robinson, Mrs. Simpson-Miller, Mr. Stewart, Mr. Terrelong, Reverend Thwaites, Mr. Dwayne Bass, Mr. Wright, Ms. Nito,
Statements by ministers.
Mr. Speaker, I wish to bring to the attention of the House the sad news of the passing last night, May 16th, of retired clerk to the Houses, Mrs. Sharonette Lewis, known to us as Shirley Lewis. Mrs. Lewis spent most of her working years in the legal system, firstly in the court's office, then as Crown Counsel, following which she served as a resident magistrate. In June 1994, Mrs. Lewis entered the parliamentary service on assignment and subsequently appointed as clerk to the Houses and served until August 2006, followed by a retirement from the public service. She leaves behind two daughters, Miss Althea Lewis and Dr. Karen Lewis Bell, son-in-law, grandchildren, and other relatives. On behalf of the government, we offer condolences to the family. On a personal note, Mr. Speaker, we found Mrs. Lewis a very quiet, pleasurable person when you meet her outside of Parliament. Very jovial, and as I said, we will miss her, although she has not been really active in recent years. We have no, it's a lot too early to have any further information, but members, particularly those who were in the House at the time she served, will be given information as to funeral service.
Dr. Phillips.
Thank you, Mr. Speaker. I would like to join with the leader of the House in expressing condolences, particularly on behalf of the opposition, on the occasion of the passing of Mrs. Shirley Lewis. For most of the period, in fact, say for 1 year, when the first year I was leader of the House during her tenure as clerk of the Houses of Parliament. And I can say, Mr. Speaker, that she was present and instrumental in some of the more far-reaching reforms that took place in the operations of the House during that period. In particular, the implementation of the committee system that we now have, with the standing sessional committees such as the Committee on Infrastructure, Human Resource Development, etc. She was, in fact, the clerk during the years when those committees were established. She also, I think, it should be noted that she was also very avid in ensuring that the Parliament was represented and active in the Commonwealth Parliamentary Association, and made extensive effort in trying to raise the quality of the conditions in the House. So we are all grateful for her efforts as clerk of the House in trying to continue and raise the standards of the House. As we all know, there is a limit to what can be done without entirely new facilities being provided. Nevertheless, we applaud the efforts that she made. Mr. Speaker, her service, not only to this Parliament, but I believe to Jamaica, as a resident magistrate, as counsel, as clerk of the courts, has been exemplary. And I would join with all my colleagues here in asking that the clerk of the House extend to her family the condolences of the entire Parliament on the occasion of her passing.
Mr. Speaker,
Minister Montague.
I too would want to join the sentiments with regards to the passing of Mrs. Lewis, but more to speak to her community involvement, especially after she left the job as clerk. She engaged herself in a lot of church and community work. She gave voluntary service to the children, the Office of the Children's Advocate. She worked while I was Minister of State for free, gave voluntary service to help us at local government to flesh out the Ananda Alert system. She was also heavily involved in the United Church of Jamaica and the Cayman Islands. And I know Dr. Guy was present at an event when she handed over some musical instruments at Salem United Church. She hails from St. Mary, Islington to be exact. And after a very brief illness, she passed peacefully at home last night. The parish of St. Mary and the extended family is extremely saddened by her passing. And we are, as a member of the family, we are grateful for the sentiments being expressed for her. Thank you.
The following is a message from the President of the Senate to the Honourable House of Representatives. I have the honour to advise the Honourable House of Representatives that on the 21st day of April 2017, a bill entitled An Act to Facilitate Domestic and International Trade and Commerce by encouraging the use of arbitration as a method of resolving disputes, to repeal the Arbitration Act 1900 and for connected matters, was passed in the Senate with 50 amendments for which the Honourable Senate desires the concurrence of this Honourable House, and the amendments have been circulated. Signed, Thomas Tavares Vinson, QC CDJP, President of the Senate.
Mr. Speaker, I now move that the Senate amendment to the bill shortly entitled the Arbitration Act 2017 be considered and approved.
Those in favor? Aye. Those against? Ayes have it. Petitions? Papers? Reports from committees? Notices of motions given orally. Questions and answers to questions. Motions that may be made at the commencement of public business requiring notice. Motions relating to sittings of the House. Motions for leave to introduce bills. Presentation of bills without leave of the House first obtained. Members, I have requests from a member of the House to make an explanation under Section 18 of the Standing Orders. I have advised that entertain the member. Strict rules will be followed. Mr. Samuda.
Thank you very much, Mr. Speaker. You do have that thing we use. This is an unusual item on the order paper. And I thank you very much, and I thank the House for agreeing to allowing me to make this personal explanation. Mr. Speaker, reference was made in my original document with respect to certain exhibits. but I am advised that all documents referred to in this presentation, they are available for anyone wishing to learn more in terms of the contents of these documents. Mr. Speaker, the Member of Parliament for Northwest, St. Anne, in his contribution to the sectoral debate on May 9, 2017, made accusatory statements in respect of two specific issues relating to me personally and my stewardship at the Ministry of Agriculture, without affording me an appropriate opportunity to respond. The member stated that the former CEO of the Jamaica Development Board, Mr. Hugh Graham, was fired as a result of a disagreement, and I quote, a disagreement between Graham and the minister over a granting of a license to a company to import milk powder from Colombia for resale on the local market, end of quote. The fact is that, Mr. Speaker, Mr. Graham's 3-year contract expired on May 15, 2016. And following the expiration of that contract, he was retained until a new board was put in place. It was that board, Mr. Speaker, that took the decision not to renew Mr. Graham's contract. The suggestion that I was instrumental in that decision is a categorical falsehood. I did not in any way influence the decision of the board. It is a fact that I received a letter from Wysinco Group Limited on April 27, 2016, requesting my assistance in facilitating their application, which commenced, incidentally, as far back as September 14, 2015. A review of the letter, March 22, 2016, from Mr. Graham to Wysinco will illustrate that no reason was given for the refusal to grant the requested license. However, it was noted that he would be, and I quote, happy to consider approving milk powder for use in manufacturing, particularly targeting the export trade, end of quote. I subsequently received on October 25, 2016, a letter from the law firm of Myers, Fletcher and Gordon, acting on behalf of Wysinco, stating their concerns regarding the unfair manner in which the company's application was being treated, and they requested to meet with me as a matter of urgency. On November the 4th, 2016, Mr. Graham wrote to me advising on some of the reasons that caused his refusal to support the application. On November 28, 2016, I wrote to Wysinco advising that I had consulted and as a result I would not interfere with the decision at that time. On January 18, 2017, I convened a meeting of stakeholders to review the whole issue as they had made strong representation to me so to do. Included in this meeting were all appropriate officials of the ministry. This included their plans to build a brand name through the marketing of milk powder sachets while making preparation to establish a dairy herd on 1,000 acres of land and the establishment of a plant to produce various dairy products for local consumption and export. I was advised by the officials present that the volume requested constituted a mere 3% of the unused portion, 3% of the unused portion of the allocation made for the year. This in no way posed any form of threat to the strategy of developing the dairy industry in Jamaica. Ultimately, the meeting agreed that the company should resubmit its application to the ministry through the Jamaica Dairy Development Board. At no time did I, nor would I, anyone knowing my history would appreciate, nor would I give permission for the importation to be sourced from Colombia. In letter dated April 18, 2017, the chairman of the Jamaica Dairy Development Board wrote to Wesinco advising them that the board recommended a license conditioned on Wesinco acquiring the milk powder from a source approved by the veterinary division. Mr. Speaker, the member went on to make reference to the Agricultural Credit Board and the dissolution of that board. The fact is that the Agricultural Credit Board was dissolved based on cabinet decisions spanning both administrations, when as early as 2008, the then government agreed to transfer responsibility for regulating agricultural loan societies from the ACB to the Department of Cooperatives and Friendly Societies. Mr. Speaker, it is true in respect now of another allegation. It is true that 14 acres of Mombasa grass has been planted on my farm at Knowles, St. Catherine. Similar treatment was offered and available to all registered dairy, beef, and small ruminants farmers. At no point did I use my position as a minister to benefit from this program, as from the very outset I insisted that a bill be sent to me for all charges associated with the exercise. And Mr. Speaker, let me make a public statement here. Had I had thought of it more carefully, and if the opportunity should ever arise again, I would not have gone the route that I did. It raises questions, it gives rise to speculation, and in that regard, it is unquestionably an error on my part not to have safeguarded myself appropriately. Being fully seized of the possible implications involved, I was reluctant to accept the suggestion which was made by the Deputy CEO of the JDDB, Mr. Lawrence. I did not initiate this suggestion, and in fact, was prevailed upon to accept. I have said before, I regret not having taken appropriate measures to protect my integrity and the whole process by which this is managed. At no stage, whether prior to, during, or after the exercise, was there any discussion whatsoever in respect of the quantity of land on which the grass was to be planted? He has made suggestions about a limited amount of land to be engaged. And the suggestion was made also, Mr. Speaker, that this was a provision for small farmers that I was taking advantage of. What are the facts? The facts are that several farmers have benefited, ranging from as small as 1 acre to 80 acres, and including some of the largest businesses in the country. I do not wish to name them now, and I will not. The fact of the matter is that persons who have participated in this program were not only related to non-political figures, but I have no intention whatsoever to match like with like. I will not seek to strengthen my presentation by drawing reference to anyone that it might eventually hurt, because I am satisfied that anyone who took advantage of this program did so in the earnest belief that it would improve their contribution to the development of the country through agriculture. Mr. Speaker, because I had insisted on getting a bill for the work done, I also further insisted that whatever was done be costed and the cost conveyed to me in the form of a statement. I received that statement, and Mr. Speaker, I have here the receipt of my payment for all the work done at my farm for $546,000. That I paid today. Why? Because I knew I was coming to this house and I did not want to promise to pay. I paid it knowing fully well that there is no, and the reason I am advised why it took so long is because there is no provision under the program for any participant to pay for the services that they have received, many of whom have received a considerably larger contribution to their farms than I have, who have not paid for the service, as is in keeping with the program itself. I have, and I feel more comfortable doing that. Mr. Speaker, another allegation is that there was a disagreement with the Dairy Board in relation to the planting area of 35 acres. We never discussed 35 acres. We never discussed acreage. It was never part of any conversation involving this program. I was merely participating in a program that was offered to me with the full intention of underwriting the cost of that as it relates to my farm. The people of Jamaica have elected me to this office, and I've always managed and tried my best to handle my affairs in such a manner that I would live up to the expectations of the people, what they voted me here to do on their behalf. I have never wavered from that. And as I said in the House when the statements were made, it is the first suggestion that sought to impute motive to anything I've done to benefit myself personally in 38 years. First time. But there's always a first time. All I hope is that there will not be another. Mr. Speaker, with these few comments, I hope that I have been able to make the matter more clear, and I look forward to a constructive working relationship, as I have been doing with all participants in the agricultural sector. Thank you very much.
You can ask question. No question. No question. Can I ask a question? Oh, can I make a statement?
Mr. Paulwell.
Yes, Mr. Speaker, we are very well aware of the provisions of Section 18.
You are a senior parliamentarian.
Is there a written... I'm inquiring.
I'm going to send you, Mr. Paulwell.
Yes.
I don't know what you're going to say.
No, I'm asking if there's a written document, a written presentation.
Not in this matter.
Yes.
Okay.
Yes. Right.
Question.
Because obviously the member from Northwest St. Anne is not in the House. So we would like for him to be furnished with this, and also for the opportunity under the same section to avail to him to do a similar response next week.
Mr. Speaker, I have a question.
Mr. R. Scott, if you look at the standing orders, item 18, I stated clearly the minister or any member can have an explanation. There will be no discussion, no question, no answer. Public business.
Mr. Speaker, public business this afternoon. The resolution in relation to the political parties registration will be debated. We expect the debate to continue and an act to amend the Companies Act. Under this sectoral debate, we will have 3 presenters: the Attorney General and Member of Parliament for West Central St. James, the member from St. Catherine North Central, and the member from Clarendon North. Mr. Speaker, we will move in that order, and as such, we will begin with the registration of the regulations in relation to registration of political parties, which I will do in my capacity as Leader of the House. Mr. Speaker, I hereby submit for the consideration of this Honourable House a set of regulations entitled the Political Parties Registration Regulation 2017, which have been made by the Electoral Commission of Jamaica pursuant to Section 104(1)(a) of the Representation of the People Act. The purposes of these regulations are as follows. 1, to provide a framework for the registration and deregistration of political parties. 2, to establish the procedure for registration, deregistration, and objections to the refusal of an application for registration by the Commission. And 3, to facilitate a system whereby an accurate and up-to-date record can be kept on each political party in operation. Mr. Speaker, political parties, like civic organizations, must be registered in the interest of democracy. The political party must be transparent and must meet international standards of accountability and transparency. The registration of political parties would therefore function to make our democracy stronger and more modern. It is the desire of the Electoral Commission of Jamaica that all political parties that intend to contest the polls in parliamentary elections, parish council elections, KCC elections, municipal elections, and referenda to be registered with the Commission. Under Section 104(1)(a) of the Representation of the People Act, the Electoral Commission of Jamaica may make regulations subject to affirmative resolution for the purposes of giving effect to the provision of Part VB of the Act, and in particular, these regulations may be made in relation to A, the conduct and operations of political parties, B, prescribing the form of application for registration of a political party, C, the form and manner in which records of donation shall be kept by political parties, D, keeping of records of state funding by political parties, and E, the manner and form of submitting annual financial reports and statements. The Political Parties Registration Regulation 2017, Mr. Speaker, these regulations laid before this Honourable House are premised primarily on the provision of Part VB of the Representation of the People Act and comprises 20 regulations which make provision as follows. Regulation 2 sets out the definition of certain key terms used throughout the regulations. Regulation 3 to 7 stipulate the form and the manner that the application for the registration of a political party shall take, as well the necessary documents, statements, certificates, declarations to be submitted to the Commission in support of such application. Regulation 8 sets out the procedure for an application for voluntary deregistration of a political party. Regulation 9 provides that a register of political parties is to be kept by the Electoral Commission of Jamaica and it also prescribes the nature and form of this register. Regulation 10 stipulates that a political party must, before the last day of January in each successive year following the initial registration, submit a written declaration as to the continued existence. So, Speaker, Regulation 11 to 12 prescribe the procedure for changing or altering the name, identifying symbol, slogan, or color associated with a political party, and instructs that a new certificate must be issued when the name of a registered political party is changed. Regulation 13 stipulates that where a registered political party changes the location of its head office or changes its postal address, it must, within 14 days of the change, notify the registrar in writing or by electronic format. So, Speaker, Regulation 14 prescribes the form that a notice of proposal to deregister a registered political party should take. Regulation 15 outlines the time, form, and manner in which every registered political party should submit to the registrar a copy of its annual financial report. Mr. Speaker, Regulations 16 and 17 relate to notices to be signed by office holders and notices to be signed by the registrar. Regulation 18 sets out that any person who knowingly makes a false statement or knowingly furnished false particulars in any application or other documents required by these regulations commits an offense and will be liable to summary conviction or a fine not exceeding $1 million or to imprisonment for a term not exceeding 6 months. Mr. Speaker, Regulation 19 provides the procedure to appeal against the decision of the Commission not to register a political party. Regulation 20 outlines the specified fees payable in respect of the certificates and other forms of authorization and services provided by the Commission. In support of the regulation, 2 schedules are included setting forth the forms, required documentation, or information as prescribed in the respective resolution. Mr. Speaker, I invite other comments at this time.
Mr. Paul.
Mr. Speaker, the opposition welcomes and supports the regulations that are presented to us for contemplation and approval today. Indeed, we could not do otherwise. As Mr. Speaker, you'll recall that the bill and law were done during the former administration. At the time, the government took the decision, in keeping with the recommendations of the Electoral Commission of Jamaica, to enact legislation for the registration, regulation, and funding of political parties. At the time, we had received the report from the ECJ that there was no requirement for registration of political parties in Jamaica or for the regulation of their financial arrangements. The ECJ was of the view, and we supported it, that given the vital and important role of political parties in the affairs of the country, such a situation was no longer tenable. In the report of the ECJ, there was a recommendation that all political parties that intend to contest the polls in parliamentary elections, parish council elections, KSAC elections, and municipal elections be registered with the Commission. So this is really very far-reaching, because before now, anybody could get up and decide that they are going to form a political party, and they will be able to contest elections. This law and the regulations that are now being enacted will change that. And in fact, the ECJ will be the body that will receive applications for registration, and for parties to participate in the electoral process. This is now an activity that must be adhered to. So it is quite far-reaching, Mr. Speaker. The law provides for the registration of political parties and the procedure for registration. It also provides for the procedures for refusal of and objection to applications for registration. Deals with proceeding for the deregistration of registered political parties. Procedures for application for state funding, the qualification for state funding, the obligation of political parties that qualify for state funding. It also deals with the use of state funding, and very importantly, the financial requirement, the financial reporting requirements for the political parties. So it is in that context, Mr. Speaker, that we do support these regulations, and the Minister has gone through all of them. There are just a few that I would wish to highlight. For example, Mr. Speaker, Regulation 10 is that a registered political party shall, before the last day of January in each successive year, following its initial registration, submit to the registrar a written declaration made by the president or leader and the authorized representatives of the political parties in the form set out here. The registrar being the ECJ office. And very importantly, Mr. Speaker, any person who knowingly makes a false statement or knowingly furnishes false particulars in any application or other document required by these regulations commits an offense. And this is quite serious, because that offense, if found to be so, can land that person with a fine not exceeding $1 million or to imprisonment for a term not exceeding 6 months, or to both. So Mr. Speaker, these regulations fulfill the new provisions of that new law and will give effect to those provisions and fulfill the desire on our part to have more transparency in the operations of political party. As you know, it's a companion set of legislation, starting with this, dealing with registration. It also deals with state funding. But very importantly, we did pass campaign finance legislation that sets out new rules governing campaign finance, and I would like, when the Minister comes to respond to our comments, to give us an indication as to the timetable now for the regulations governing campaign finance. These have been outstanding. Again, the law was passed by the former administration, and we don't believe that we should proceed to further elections without these regulations being in place for the law to be given effect. So, Mr. Speaker, the opposition supports these regulations, and we commit them for the House's formal affirmative approval.
Mr. Speaker, just on
Minister Mackenzie.
Just on observation, Mr. Speaker, I note that there's an amendment, there needs to be an amendment to reflect the changes that has been made to the Local Governance Act, because in the bill that was presented, the minister made reference to the KCC and the Parish Council Act. The new Governance Act that was passed in this House would have totally unified all the local government services, so there is no longer a KCC Act to the Parish Council Act. So just an observation that when we get closer down, that those amendments can be made to reflect the changes as it relates to local government.
Mr. Hilton. 1 minute, Mr. Hilton. Minister, you wanted to? Just, we're coming to you then.
Mr.
Minister, you're not closing. Okay, Mr. I thought that Minister had. I thought that Mr. Mackenzie. Go ahead. The Minister will respond to Mr. Mackenzie. Go ahead, Mr. Hilton. Mr. Hilton, go ahead.
I rise to participate in this very important debate, Mr. Speaker. To agree with those who have spoken before me that this is indeed an important development in our laws and regulation governing the conduct of political parties in Jamaica. And in so doing, Mr. Speaker, it improves the quality, it will improve the quality of our democracy and also provide for the people of Jamaica an insight and a transparency in the operations of political parties, which we all believe, Mr. Speaker, will inure to the benefit of the political process. Because, Mr. Speaker, prior to this, our political parties and their operations were marked by the absence of regulation, by the absence of any requirement to provide critical information about the business of political parties, which, as we have all agreed, are much more than and are not like a number of other NGOs. Political parties, after all, are the vehicles for exercising significant power and authority over critical resources, policy decision, far-reaching decision-making, impacting the lives of
entire population of Jamaica. Mr. Speaker, I'm very pleased of the participation that I've had in this process. I recall it as a young member of Parliament when I entered this House in '93, that by '95, in my sectoral presentation to this House, I pointed out the need for, the absence of, and the need for regulation addressing critical issues of state financing, and I do believe that that is an option, that a critical adjunct to these regulations, and that have already been recognized in law and has been passed. As the Leader of Opposition Business indicates, we would like to, and we are awaiting the regulations surrounding and following on that aspect of the legislation. But suffice it to say, Mr. Speaker, today's development is important in and of itself, insofar as the regulations details the operation of the legislation which preceded it, in terms of the conditions under which the legislation will be implemented. Mr. Speaker, I recall leading the delegation to Germany, which included members of the EOJ at the time, members of the opposition then was invited, or the government, I think they were the government then, were invited to participate, and had agreed to participate, and at the last minute decided they would not participate in that delegation. But the delegation to Germany, Mr. Speaker, was a very, very important mission. It turned out to be that in the discussions that we had with the Germans about how they went about state funding of their political parties, focused on the need for, and focused our attention on the critical need as a condition for state party, for party regulations themselves, and the registration of political parties being a critical part of that. We came away from that mission to Germany very clear about a framework that could be and should be put in place to ensure that the operations of our political parties here in Jamaica would be fine-tuned, would be regulated, and would give the level of transparency and ultimately credibility for the Jamaican people to have a greater level of confidence in. And so, Mr. Speaker, having passed those pieces of legislation respecting the registration of political parties, which provide for it a governance structure, and the critical aspect of it of financial reporting, which allows for an insight as to source of financing, who finances political party, how much funding monies are spent, and how the political parties operate, I believe is very, very critical. But, Mr. Speaker, more importantly, I think it changes the culture and introduces a new element where today it's the political parties that have now to account for their sources and methods of financing. But I don't believe that it should stop there and remain there. I believe there are other actors that are critical to the process, where there will be the need to find out what are the sources of those income, who finances, and for what purposes, if we are going to be accountable, one, and to refine our political process and the exercise of political influence in this country. So, Mr. Speaker, I do agree with those speakers before me that today's development will redound to the benefit of Jamaica, to the Jamaican people, and to the democratic process in Jamaica. And I believe the time is high time, and the time has truly come for us to be moving in this direction. And I do look forward to the additional regulation to come on the state funding aspects, which I believe are necessary corollary to today's development. I thank you, Mr. Speaker.
Mr. Speaker, we appreciate the points made by all the speakers, the Leader of Opposition, business in the House offered concurrence on behalf of the opposition in relation to this long outstanding matter. He did highlight that part two, or the other leg of to tighten up this whole matter, campaign financing and political parties funding. That's being actively worked on at this time, and in short order, we expect it to be tabled and brought to the House. The point made by the Minister of Local Government is very essential, what I would call an oversight, and that appropriate adjustment will be made accordingly. Mr. Speaker, having said that, I move that the resolution may be cited as the Political Parties Registration Regulation 2017, and 2, the Political Parties Registration Regulation 2017, which was laid on the table of the House on the 9th day of March 2017, I hereby affirm.
Minister, before I put the question, Minister Mackenzie had a presentation. Was it in reference to this bill, Minister, or I can proceed?
No, Mr. Speaker, it is just a simple amendment to the bill to make reference to local government in general, instead of separating the KSAC and the parish council, which no longer exists under the new local government framework, which the minister has indicated that the necessary amendments will be made.
I've been advised, Minister, that the regulations cannot be amended this way. So you may seek to put your...
Mr. Speaker, it may be, and I propose for your consideration that rather than we passing this now and have to go through a long process to secure those amendments, which are obviously not controversial, that if we were to suspend the debate on this at this time, then appropriate consultations could take place between the minister with responsibility, the leader of government business, the leader of the House, that may enable us to secure appropriately amended regulations and then proceed. If that may be more convenient for everyone, rather than have a regulations with a deficiency going forward.
Minister Smith.
Mr. Speaker, I don't think it can be classified as a regulation with a deficiency. It's a simple matter just to adjust, and that's a term I prefer to use. The reference here to parish council, KCC, other than just municipal corporation, it's an adjustment, and I am told that we don't really need an amendment accordingly, so I have to be guided. May I just, Mr., gain some Mr. Speaker, thank you very much for the time, sir. I'm advised by very competent legal personnel that we do not need to do any amendment or any change at this time because it has already been adjusted and amended under the Local Government Act. Accordingly, I again move that it be affirmed. The resolution be affirmed.
All right, we proceed. The question is that
Mr. Speaker, I just need some clarification on the matter. No. Just some clarification, because there are times, Mr. Speaker, when we all speak and we still continue to make reference to the parish councils as parish councils. Are you saying, member, based on the legal advice? Because the document that is presented here says the KCC and the parish councils under the new governance act which was passed in the parliament, it no longer exists. So this document is presented and tabled representing those views. So, I just need to get the clarification on the matter. It's not controversial. It's not that we're not talking to anybody. Not like what they do you the other day, Peter. Okay? So just need some clarification for it. It has to be corrected. And I agree. I cannot accept
What is it, Mrs. Cook?
that recommendation coming from the legal emissaries on the matter.
Mr. Hilton, use the other mic, Mr. Hilton.
I would tend to agree with the member, Mr. Speaker, who is asking for clarification, because if the response is that the act that was previously passed amended the laws, the previous laws, then it shouldn't be that this is a later in time piece of legislation which doesn't make reference to. It seems to me the clarity would be there if the act which amended the previous legislation would be referenced in this, so that you don't have a continuation of the old reference in a new piece of legislation that came after the legislation amended the first one. So I would tend to agree with the member that for clarity and for consistency, that we don't continue to use the old form, but that we take account of the amendments that have already been made in law, especially since these are subsidiary regulations.
Mr. Speaker, I'm again advised that the error that's been highlighted by both the minister and others is in relation to the brief, but it was not mentioned in the regulation that was tabled in the House, the date. So what the error is in relation to the brief, but not to the regulation. The regulation was tabled. There's no reference accordingly.
Mr. Speaker, I am satisfied, and thanks for the information. Thanks.
Thank you, Mr. Minister. The question is that the resolution be now approved. Those in favor? Those against? The ayes have it.
Mr. Speaker, as indicated, we'll continue debate on an act to amend the Companies Act.
No, you're going to close. I'm going to go down the bill now. He's going to speak. Everybody's going to speak.
You spoke last week, right?
No, I opened last week, but
You're not closing that.
I'm not closing.
Well, let him speak then.
No, but I was going to give the clause by clause. Clause by clause.
Mr. Samuda.
No, but there's a point I was making last week.
Mr.
You
Samuda.
can do it again. You don't want me to get two shots at the chair.
No.
You don't want me to get two bites.
Order.
You
Mr.
prefer if I
Samuda.
don't get two bites.
Yes.
Minister Samuda.
Yeah, we don't need
Minister.
clause by clause.
You know the clause by clause. So when I close, I go clause.
Minister Samuda. Minister.
When I close, I can go clause by clause. It's selfish.
Mr. Samuda, when you're closing the bill,
It's already decided.
you may go through all of those stages.
That's what.
At this time, we want to recognize Mr. Hilton to speak, and then you can take full charge, make your presentation, and close the bill.
Thank you very much, Mr. Speaker. I'll be guided by your directions.
Mr. Speaker,
Mr. Hilton.
my intervention in this regard will be very brief. Firstly, Mr. Speaker, to say that the amendment to the Companies Act are long-sought amendments that I tried to bring forward in the previous administration. But it was made part of a wider set of amendments which made it difficult in time for us to bring forward these particular amendments, which are very narrow in their focus and scope. And for reasons having to do with some practicality, my understanding being that the government is under some pressure to have this matter addressed at a certain time. And it's a matter I can relate to, Mr. Speaker, because as I've been said in this House before, both sides have a shared vision for the financial services sector to develop in Jamaica. And to that end, legislation have already been brought in this House and supported by us, the opposition, because we had progressed those legislation to a very advanced stage. And so, Mr. Speaker, I recognize these amendments as amendments consistent with our obligation or responsibilities as members of both the Global Forum and the Caribbean Financial Action Task Force, which requires for us to be in conformity with existing or emergent standards, global standards, and not to be blacklisted, that we have to amend our Companies Act to be consistent with those requirements. And essentially, the requirements are about transparency, levels of transparency, particularly to prohibit what is called share warrants, which allows for the beneficial owners of shares in companies or decision makers in companies not to be registered as members of those companies in the various registry for participating members. This is viewed, while that used to be okay at a time past, in the current dispensation, these are being frowned upon as action not consistent with the levels of transparency that is required globally. And it is, in fact, deemed to be not helpful to the level of transparency and for matters like AML or in these cases to support tax evasion, tax avoidance. Because we intend to participate in the financial services in the ways that we have described previously, we really want to make sure that we are in conformity with the new emergent is not blacklisted, and that we are in good stead. We continue to be in good stead if we make and keep to these amendments. And so the opposition has no objection to the amendments as they are presented here today. Thank you, Mr. Speaker.
Mr. Tweed.
Thank you, Mr. Speaker. Mr. Speaker, I will be brief. The amendments to the Companies Act are appropriate. One remembers the whole-scale reform that took place several years ago. I would like the Minister to consider whether the amendments could be furthered and the progress of commerce be advanced in Jamaica, inuring to greater growth, if provisions analogous to Chapter 11, Chapter 13 of the American Commercial Code would be included also. Many times, there are companies which need a period of administrative management, of restructuring, and it is my query and my submission at the same time that the present reforms and the existing legislation fall short of that, and that our entire commercial climate would be bettered if these were introduced. And I crave his attention and cooperation in this matter.
Minister Samudo.
I thought there were going to be a lot more.
Close it now and go to committee, okay?
Yes. They do. No, we won't. Mr. Speaker, I thank the members for their contribution, and I would like to particularly indicate where it is so vitally important that we seek through this measure to conform with our international obligations in respect of transparency, accountability, and good governance. And the information in relation to beneficial owners is very critical, because we have been in the past plagued by the hidden hand that controls the management and has control over the operations of the company, but not visibly so. This will ensure that those beneficial owners are part of the public record so that they can be viewed and assessed. The ownership and the information about the ownership being in the hands of the public and a potential investor in the company is very important if we are to accord with accepted international standards for tax transparency and compliance, the detection of financial crimes, and for a governance regime conducive to foreign investment. So the member from Western St. Andrew is quite right in pointing out how critical this is to the whole process of making Jamaica a more attractive investment destination. Mr. Speaker, the contents of the bill are as follows. Clause 1, it's a short title and construction. This clause provides for a short title of the Act. Clause 2, amendments of the Principal Act. This clause provides for the deletion of the word "the island" and also its cognate expressions wherever they appear, and substituting therefore the word Jamaica. Clause 3 amends this section 2 of the Principal Act. The amendment to clause 2 introduces definitions of certain key terms which are used throughout the Act. Noteworthy is the definition of the term beneficial owner, which is a key term in the context of our amendments, which is divided into two aspects. A relation to shares, and B, in relation to a company. The section also provides for the definition of ultimate ownership, which means any situation in which ownership of a company is exercised by means of control over other than direct control. The clause also provides for the deletion of the term share warrant. I have to be so careful, Honourable Prime Member from Northeast Manchester, because, you know, I have made certain errors in the past. I don't want to make any right now. So it is best that I stick to what is provided and which they are going to insist on having. Clause 4. Clause 4, amendments of Section 8(6) of the Principal Act. The current section provides for a private company to file its articles of incorporation in accordance with the forms set out in the relevant tables of the first schedule. The section was amended to include only the articles specified in the relevant tables of the first schedule. Reference to form is deleted. Clause 5, amendment of Section 58(4) of the Principal Act. This section currently provides that a company shall not make any payment to purchase or acquire shares issued by it unless a statutory declaration is made by the company's directors in accordance with the Act. The section was amended to include the word majority to state that the statutory declaration shall be made by a majority of the company's directors. Clause 6, amendments to Section 60 of the Principal Act. This section currently provides that a company shall notify its shareholders within a specified time of the purchase of its issued shares. This section was amended to indicate that the registrar shall also be notified along with the shareholders. Clause 7, amendment of the Section 82 of the Principal Act. The section currently provides for the issuance and effect of share warrants to bearer. The amendment provides for the section to be repealed, given that the issuance of shares warrant is prohibited in the light of accepted international standards. And the member from Western St. Andrew is well aware of that. Clause 8, amendment of Section 109 of the Principal Act. The section currently provides for every company to keep a register of its members and to enter therein particulars of the names, addresses, and occupation of its members. The section was amended to include the nationalities of the members and also particulars in relation to beneficial ownership. In respect of beneficial ownership, the entry relates to the member shall specify that the ownership of the member is on behalf of a beneficial owner. Clause 9, repeal of the Section 111 of the Principal Act. The section currently provides for entries in the register in relation to share warrants. The amendment provides for the section to be repealed given that the issuance of share warrant is prohibited in light of accepted international standards. Clause 10 repeals and replacement of Section 116 of the Principal Act. The section currently provides that no trust expressed, implied, or construed, or both, shall be entered on the register. The section is amended to provide that where a company has notice of any trust affecting the membership of the company shall enter the particulars of the beneficial owner in the register. The section was also amended to provide that a company shall once per year or at least such times as the registrar may direct in writing request its members to advise whether they hold property in the company on behalf of a beneficial owner and supply the particulars of the beneficial owners thereof. The amendment further provides that where a company, member, or beneficial owner without reasonable excuse makes a default in complying with the provisions of this section, a fine of $500,000 will be imposed. Clause 11, amendment of Section 122 of the Principal Act. The section currently provides that every company having a share capital shall make an annual return containing a list of all persons on the date of the return and who members of the company and persons cease to be members on the date of the last return. The section is amended to provide for the inclusion of beneficial owners on the list. The amendment further provides that the list shall contain all those persons who cease to be beneficial owners of the company. Clause 12, amendment of the Section 172 of the Principal Act. The section currently provides that a private company shall have at least one director, but a public company shall at least have 3 directors. The section further provides that every company shall have a company secretary. The section is amended to provide that within 15 days after the date of appointment of a director or a secretary, the registrar shall be notified in writing of the appointment. The amendment further provides that where a company fails to comply with the requirements of the section, the company shall be liable to a fine not exceeding $500,000. This section, however, does not apply in respect of a vacancy of the office of director or secretary for a period of less than 3 months. Clause 13, insertion of new section 174A in the Principal Act. A new provision has been included in the section to provide that it is the duty of a director to avoid circumstances which, whether direct or indirect, constitute conflicts of interest, or may result in a conflict of interest with the interests of the company. No, that's it. Or both. The provision further provides the circumstances in which the duty is not infringed, such as where the circumstances cannot reasonably be regarded as likely to give rise to a conflict of interest, or where the circumstances have been approved by the directors. Clause 14 amends its amendment of Section 177 of the Principal Act, and this section currently provides for directors or officers to hold a specified share qualification, and that the bearer of a share warrant shall not be deemed to be the holder of the share specified in the warrant. The section is amended to remove the reference to share warrants, given that the issuance of share warrants is prohibitive in light of the accepted international standards, and also to amend the marginal note to correct the spelling of the word qualification.
You're running
Clause 15, amendment of Section 201 for the Principal Act. The section currently provides that a company may indemnify a director or any person employed by the company as an auditor against all costs, charges, and expenses. The section is amended to change the word any to a. The section was also amended to change reference to subsection 2 to subsection 1 in paragraph 3. Clause 16, amendments of the section 2093 of the Principal Act. The section currently provides that an instrument of transfer shall not be required for any share for which a share warrant is for the time being outstanding. The section is amended by deleting the provision making reference to share warrants thereto. The issuance of share warrants is prohibited in light of the accepted international standards. Clause 17, amendment of Section 2123 of the Principal Act. The current section provides that the definition of the word compliant means a shareholder or former shareholder of the company or an affiliated company, the single order. Clause 19, amendment of Section 213A of the Principal Act. The section currently provides for the remedy of the court in case of oppression. The section is amended as follows in paragraph 2b. A, by inserting the word or after the semicolon at the end of the paragraph. B, by inserting the words or unfairly disregards the interest of after the words prejudicial to in the closing paragraph. This is to expand the reach of the remedy. The section is also amended to remove reference to bylaws, since the present Companies Act does not refer to bylaws. Clause 20, amendment of Section 2221 of the Principal Act. The section currently provides that a winding up petition shall not, if the ground of the petition is in default in delivering the statutory report to the registrar or in holding the statutory meeting, be presented by any person except a shareholder. The section is amended by replacing the word shareholder with the word member. 21, Clause 21, amendment of Section 363(1) of the Principal Act. The section currently provides that companies incorporated outside of Jamaica shall deliver documents to the registrar containing, among other things, a certified copy of the charter, statute, or articles of the company, and a list of directors of the company. The section is amended to provide that the company shall also deliver to the registrar a list of members and any beneficial owners containing such particulars required to be entered in the registrar of members of the company. Clause 22, insertion of Section 363A in the Principal Act. A new provision has been included in the section to provide that a company incorporated outside of Jamaica, which establishes a place of business with Jamaica, to keep a register of its members to be referred to as Overseas Branch Register. Clause 23, amendment Section 365 of the Principal Act. Section 365(1) is amended to delete in paragraph A and B the words or, and also to include in the register alterations made in relation to beneficial owners of the company. The section is further amended to increase the time frame from 21 days to 28 days to deliver the alteration to the registrar for registration. The section is also amended to provide a new subsection for the definition of the word certified to mean less than 2 directors, or a director and the secretary, or a notary public to be a true copy. Clause 24, amendment of the Section 366 of the Principal Act. The section currently provides that every company incorporated outside of Jamaica shall in every calendar year make out a balance sheet and profit and loss account. the section is amended to change the period from every calendar year to within 18 months of registration of the company and thereafter in every calendar year. Clause 5, amendment of Section 370 of the Principal Act. The section currently provides for penalties under which the part applies, which is companies incorporated outside the island carrying on business within the island. The amendment seeks to provide for an increase in the fines and not exceeding $50,000 to $2 million where a company fails to comply with the provisions of this part. Clause 26, insertion of Section 383A in the Principal Act. A new provision has been included in this section for the prohibition of share warrants. Where a person contravenes this section, that person is liable on summary conviction in a parish court to a fine not exceeding $1 million. The section also provides for the definition of share warrant. Clause 27, insertion of new Section 390A in the Principal Act. A new provision has been included in the section to provide that every company shall keep such books, documents, or records for not less than 7 years, or such other manner as may be prescribed. The section provides that where a person contravenes this section, the person shall be liable on summary conviction in a parish court to a fine not exceeding $5,000. Clause 28, insertion of the new section 396, 397, and 398 in the Principal Act. New provisions have been included in the Act to provide for the transitional arrangements of share warrants. The section provides that upon the specified date where a person is the bearer of share warrants, that person shall be deemed to be the owner of the shares specified in the share warrant and a member of the company. This section further provides that within 18 months of the specified date, a company shall issue a share warrant to a bearer before the specified date shall withdraw the share warrant. Where a company is in default of this section, the company and every officer who knowingly causes the default is liable to a fine not exceeding $2 million. The sections also provide that the registrar shall cause a notice to be given to the public, published in a daily newspaper circulated throughout Jamaica, of the prohibition to bearers of the share warrant. Clause 29, repeal and replacement of the first schedule to be of the Principal Act. The amendment to the section provides for the deletion to the reference of forms in the various tables to the first schedule. The tables to the first schedule will only contain articles of incorporation only. Clause 30, amendment to the fifth schedule to the Principal Act. The section provides for the amendment to Form 19A and Form 19B to the schedule to facilitate the list of beneficial owners of shares in a company. Clause 31, amendment of the company's forms rules. The schedule is amended by deleting the word Section 393(3) and substituting Section 393. The bill also contains the memorandum of objects and reasons.
Thank you very much.
In keeping with international standards, the bill is significant for Jamaica to meet its international obligations by May 2017. The bill seeks to amend the Companies Act to include provisions that ensures that Jamaica conforms to accepted international standards for the tax transparency and the exchange of information for tax purposes. It should also be noted that Jamaica will benefit from the enhancement of this legislation in a number of ways, including increased ranking in the Doing Business report and also to provide a governance regime conducive to foreign investment. Thank you very much, Mr. Speaker. But, Mr. Speaker, before I take my seat, I wish to move that the bill be read a second time. But even before that, I wish to correct something which I omitted. Mr. Speaker, we had a most tragic occurrence at the Company's Office when the Director of Company's Office of Jamaica, Mr. Hugh Jones, passed away very suddenly while engaged in redesigning a section of the Company's office. He fell and never recovered, died of a massive heart attack, and I wish to extend on behalf of all of us our sincerest sympathies and condolences to his family. Thank you very much, Mr. Speaker. I now move for second reading of the bill.
The question is that the bill be read a second time. Those in favour? Those against? The ayes have it.
A bill entitled An Act to Amend the Companies Act read a second time.
The House will now resolve itself into a committee of the whole House to consider the bill clause by clause.
But I have a little amendment here.
No, do like from section 1 to 11, then you take the 12 amendments, then 13 to 30.
Okay. Mr. Speaker. Mr. Speaker.
Mr. Chairman.
Mr. Chairman. Might I suggest, Mr. Chairman, since there appears not to be any controversy in the matter before us, could I suggest that we take 1 to 11, and then we will deal with 12, and then we go from 13 to 31. In that way, I think we would be well served in terms of expediting this process.
I second. I beg to second that.
Aye. After the words A, substitution 2, the following subsection.
I know that. I put the amendment. Those in favour? Those against? As of it. I put clause 12 as amended. Those in favour?
Aye.
Those against? As of it.
30.
I put clauses 13 to 30. Those in favour?
Aye.
Those against? As of it.
(31), Mr. Chairman.
Minister, 31, you have an amendment.
There's an amendment of the Companies Forms Rule 2005. And we wish to delete clause 31 and substitute therefore the following. Clause 31. As circulated. The Companies Forms Rule 2005 is amended by deleting the words section 393(3) and substituting therefore the words section 393. And in B, the schedule by deleting Form 1A, Form 1B, Form 1C, and Form 1D, and substituting therefore the following forms. Open bracket, where
insert new Form 1A, Form 1B, Form 1C, and Form 1D, close bracket.
I put clause 31 as amended. Sorry, I put the amendment. I put the amendment to clause 31. Those in favor?
Aye.
Those against? As have it. I put clause 31 as amended. Those in favor? Those against? As have it.
Ayes have it.
I put the title and enacting clause. Those in favor?
Aye.
Those against? As have it. The question is that I do report the bill as having passed committee stage with amendment. 2 amendments. Those in favor? Those against? As of it. I do I do report the bill as having passed committee stage with 2 amendments. Those in favor? Those against? As of it. Minister. Minister Samuda.
I now ask for third reading of the bill.
Those in favor? Those in favor? Those against? As of it.
A bill entitled An Act to Amend the Companies Act, read a third time and passed.
Mr. Speaker, we continue sectoral debate, and the first presentation will be from the... No, can this have... Maybe that after, man, when you finish. The Attorney General will make the first presentation.
We now hear the Attorney General. Mr. Swart, you may proceed.
May it please you, Mr. Speaker. As a representative of the people of the St. James West Central constituency in this Honourable House, entrusted with the additional role of Principal Legal Advisor to the Government of Jamaica, I remain humbled by the votes of confidence and the trust reposed in me by our party leader and Prime Minister, the Most Honourable Andrew Holness, and also by my constituents. I am deeply indebted to all my companions on this amazing journey. To my friends and family, especially my husband Ian, I say thank you for your love, Mr. General, and especially my secretary and personal assistant. I also say thank you. Mr. Speaker, the Solicitor General, Mrs. Nicole Foster Pusey, Queen's Counsel, the two Deputy Solicitors General, Dr. Cathy Brown and Mrs. Marlene Aldred, and other members of staff from the chambers are present here in this Honourable House. Although our workload at the chambers is heavy and our resources are inadequate, our collective commitment to keep government legal is without question. Mr. Speaker, the Honourable Delroy Chuck, Minister of Justice, is most congenial and collegiate. It is a delight for me to have him as my minister. Within the cabinet, I appreciate his fierce defense of the people who work within the various departments of the Ministry of Justice. And I must say, for the record, it is a real pleasure to work alongside him. Mr. Speaker, I also want to express my gratitude to the close protection officers assigned to me. I commend them for their high level of professionalism and also for going above and beyond duty to ensure my safety and comfort on our regular commutes between the constituency in St. James and the Chambers and Parliament here in the corporate area. Mr. Speaker, I join in congratulating the new Leader of Opposition and commending the former leader for her sterling contribution to politics and public service. Most Honourable Portia Simpson-Miller, I wish you well. My last presentation, Mr. Speaker, gave rise to numerous questions in the court of public opinion about the role of the Attorney General. I was even depicted in cartoon land as the gun-wielding vigilante on the verge of shredding the Constitution to pieces to fight crime. To those who harbor doubt about my personal unwavering commitment to ensure that the machinery of government acts lawfully and legitimately really should get to know me better, Mr. Speaker. Admittedly, as a non-minister, the Attorney General is in a somewhat anomalous place in these debates. Notwithstanding, I welcome the opportunity to speak to pertinent issues relating to the chambers. I should very much like to use it to shed further light on the role of the Attorney General beyond what is generally accepted and readily understood. The role of the Attorney General was specifically addressed at a meeting of law ministers and attorneys general of small Commonwealth jurisdictions, which I attended in September 2016 in London, England. The Commonwealth Secretariat clarified and reiterated that within the British Commonwealth tradition, the work of attorneys general cross-cut all of government with very special responsibilities for the promotion and preservation of the rule of law. Mr. Speaker, while definitions of the rule of law remain contested, I favor the one offered by the Secretary General of the United Nations, who describes it as a principle of governance in which all persons, institutions and entities, public and private, including the state itself, are accountable to laws that are publicly promulgated, equally enforced and independently adjudicated, and which are consistent with international human rights norms and standards. This definition, Mr. Speaker, places emphasis on the accountability of all individuals and institutions to the law. It reveals two key functions of the rule of law. Firstly, the rule of law protects citizens from the state by curbing arbitrary and inequitable use of state power, as law also binds the sovereign. Secondly, the rule of law protects the lives and property of citizens from infringement or assaults by fellow citizens. The promotion of the rule of law at the national and international levels is also identified as one of the targets by which Sustainable Development Goal 16 on peace, justice, and strong institutions is to be measured. From this, Mr. Speaker, the Commonwealth Secretariat has articulated the view that the rule of law serves a dual role of, one, an end of development, in that the 2030 agenda recognizes its importance as one of the economic, social, and environmental aspects of sustainable development, and two, an enabler in the achievement of the Sustainable Development Goals. Mr. Speaker, it is also recognized that the rule of law requires measures to ensure adherence to the principle of supremacy of law, equality before the law, accountability to the law, fairness in the application of the law, separation of powers, participation in decision-making, legal certainty, avoidance of arbitrariness, and procedural and legal transparency. It is against this backdrop, Mr. Speaker, and within this context, that I aim to guide the actions of the Wholeness Administration. This update, therefore, focuses on some of the critically important work done by the Chambers in support of the wider work of government over the past year. It is important to remember that lawyer-client privilege attaches to most of what we do. As such, I'm constrained in how much detail I can discuss on some matters. Mr. Speaker, in my last sectoral presentation in July 2016, I disclosed that the centralization of legal services was a plank in the public sector modernization program of the government. In January 2016, the cabinet of the previous administration had approved the proposed framework for the centralization of legal services. The implementation of this framework was included in the Government of Jamaica's November 2015 Letter of Intent to the International Monetary Fund. Our administration committed in a later Letter of Intent to the IMF, dated August 30, 2016, to centralize legal services within the central government by March 2018 under the Office of the Attorney General, with the support of Justice Undertaking for Social Transformation Program, what is popularly called Just Canada. This commitment, Mr. Speaker, to centralize legal services was also recently mentioned in the government's March 29, 2017 Letter of Intent to the IMF for our precautionary standby arrangement, which was approved by the Executive Board of the IMF in November 2016. In July 2016, I had also informed this Honourable House that Cabinet would then be shortly reviewing the proposal for centralization of legal services to determine the way forward. Mr. Speaker, I am very pleased to advise that in September 2016, experts provided by the kind assistance of the Government of Canada through the Just Canada program completed and presented to the Chambers and the Ministry of Justice a detailed and comprehensive proposed phased implementation plan, which was eventually approved by Cabinet in January 2017. The Government of Jamaica once again expresses its thanks to the Government of Canada for their commitment and continued support for the reform of our justice sector. The phased implementation plan for the centralization of legal services, as approved, will involve a reorganized and expanded organizational structure for the chambers. One important aspect of the new structure is the creation of an additional 3 Deputy Solicitor General posts, moving the total from 2 to 5. Going forward, Mr. Speaker, each Deputy Solicitor General will head a specialist division and manage a number of legal service units of the line ministries, and all ministers ought note. Legal officers in those ministries and their departments and agencies will become a part of the chambers, although they will remain physically located in the ministries. The intention, Mr. Speaker, is to give the legal officers within the ministries the authority to address certain matters without the need for them to refer to the chambers as the head office. Standards and protocols will be put in place to ensure consistency and quality legal service. This will facilitate speedier turnover and assist in giving head office the capability to focus on reducing the backlog of matters within the chambers. I am further pleased, Mr. Speaker, to inform this Honourable House that funding has been secured from the Inter-American Development Bank for the emoluments of the project transition team, because the implementation plan is to be pursued through the use of a temporary full-time project transition team. We thank the Public Sector Modernization Program Implementation Unit of the Cabinet Office for its support and assistance in this regard. The terms of reference for members of the transition team are being finalized with the Cabinet Office, and recruitment is expected to commence quickly thereafter. The Just Canada program continues to support the process of centralization by drafting new job descriptions for the Deputy Solicitors General as well as the Solicitor General, among other things. Mr. Speaker, last year, I disclosed to this Honourable House the urgent need of the chambers for additional resources to enable us to successfully tackle the very heavy workload. I said at that time that I would be pressing for a special initiative to provide additional administrative and legal human resources for the chambers generally and the litigation division in particular. The Chambers is extremely grateful and happy that Cabinet, through the Honourable Minister of Justice, at the same time that it approved the plan for phased implementation of centralization of legal service, also approved the establishment of 6 additional positions for the litigation division. With, Mr. Speaker, these positions to be provided as a matter of urgency. And so, on April 25, 2017, the Ministry of Finance and the Public Service advised the Solicitor General that its Post-Operations Committee gave approval for the operation of the 3 additional Deputy Solicitors General posts, plus 3 Executive Secretaries, with effect from 1st May 2017. The approval of the Ministry of Finance is for the operation of a total of 14 new posts within the chambers, including 6 additional positions for the litigation division. The other 8 are in response to the new organizational structure being put in place for the centralization of legal services. We also had 3 positions that were upgraded. Mr. Speaker, earlier this year, in March 2017, the Chambers welcomed a Director of Documentation, Information and Access, whose responsibility includes handling the records management and access to information requirements of the Chambers. This is a new post created at the request of the Chambers, and I commend the Solicitor General for the work she has done in this regard. And it was requested to put us in a better position to manage and handle our duties. The Chambers has not had its human resource needs addressed in several years. And so I'm very pleased, Mr. Speaker, that at last some positive movement has taken place in this regard. We look forward to providing speedier assistance to the government of Jamaica and in turn to the people of Jamaica. Subsequent to my last presentation, The chambers also benefited from improved ICT resources. With the support of Just Canada, laptops, desktops, a projector, a dedicated internet line, and other ICT resources were obtained and are in use by a grateful staff. This has improved the work experience for a number of staff members who are struggling with malfunctioning equipment for some time.
Andrew.
Mr. Speaker, the improvement of our ICT resources is scheduled to continue this year as we anticipate implementation of a new file manager system for the chambers. Contract has already been signed and the development of the system is in advanced stages. Mr. Speaker, our website has also been constructed and is being populated. It will be officially launched in short order, and when it is so launched, I invite everyone to pay us a visit there.
We will.
Moving to accommodation. While the plans to refurbish and restore Justice Square are still being pursued, the Chambers has secured additional space at its current location at the NCB Towers, with a view to accommodating the expected additional staff. A measured survey of the space has already been completed, drawings are being done, and other work is taking place to have it ready for occupation in the shortest possible time. Mr. Speaker, exciting days are indeed ahead for the Chambers as we strive to better serve the people through legal advice to the government. However, Mr. Speaker, this move towards implementation of centralization of legal services under the aegis of the Attorney General seems to be retraversing the path of a Ministry of Legal Affairs. And I've already signaled to the Most Honourable Prime Minister and the Honourable Minister of Justice that some consideration may have to be seriously given to re-establishing such a ministry in order to fully achieve the gains of the public sector modernization program in this regard. I now turn to the various divisions of the Chambers and the work done over the period. Mr. Speaker, the Constitutional and Legislative Division is responsible for assisting the government in implementing the legislative agenda and ensuring that laws enacted are consistent with the Constitution of Jamaica. And this work involves vetting and commenting on Cabinet submissions, bills, draft regulations, and giving advice to Cabinet and generally to the staff and members of Parliament on proposed legislation and matters relating to parliamentary procedure. The division is also primarily responsible for advising generally on matters relating to access to information and representing the government on appeals before the Access to Information Tribunal. The division handled 2 appeals before the Access to Information Appeals Tribunal during the period, one against the Ministry of Justice and the other against the Attorney General's chambers. With respect to the first, the decision was in favor of the Ministry of Justice, and with respect to the second, the chambers did not dispute that the information should be given, and so all the tribunal had to do was to indicate the method by and format in which the information was to be released. Mr. Speaker, I believe it is important that I speak very briefly to the further role of the Attorney General in the legislative process. The legislative process of enacting a new or an amended act does not end with the passage of a bill through the Houses of Parliament. When the Houses approve a bill, the bill is reprinted and vetted by the clerk and staff to the Houses of Parliament. If no errors are found, the bill is then sent to the Attorney General's chambers for the interim report of the Attorney General. The interim report is a document signed by the Attorney General which states that the provisions of the bill are consistent with the provisions of the Constitution. And once the interim report is signed, it is then sent to the Governor-General for his assent. Mr. Speaker, the issuance of the interim report fortifies the presumption that all laws passed by the legislative branch of government are constitutional unless and until set aside by a court of competent jurisdiction. When the judicial branch is called upon to interpret the laws, the judges seek to ascertain the intention of Parliament. Mr. Speaker, the courts, in the renowned case of the Queen and the Secretary of State for Environment, through Lord Nichols of Birkenhead, explain what is meant by ascertaining the intention of Parliament. And this is what he said. He said the intention of Parliament is an objective concept, not subjective. The phrase is a shorthand reference to the intention which the court reasonably imputes to Parliament in respect of the language used. It is not the subjective intention of the minister or other persons who promoted the legislation, nor is it the subjective intention of the draftsman or of the individual members, or even of a majority of individual members of the House. These individuals will often have widely varying intentions. Their understanding of the legislation and the words used may be impressively complete or woefully inadequate. Thus, when courts say that such and such a meaning cannot be what Parliament intended, they are saying only that the words under consideration cannot reasonably be taken as used by Parliament in that way. Mr. Speaker, clarifying the intention of Parliament in the lawmaking process ahead of the court having to do so is a matter of utmost importance. Over the past year, I have picked up too many lacunae in various pieces of legislation, some passed long time ago, some recently, which could have been corrected through more meticulous and conscientious clause-by-clause review of the bills. And although I understand that in the interest of time we sometimes shortcut the process, Mr. Speaker, it's important that we understand that good laws will make better laws, and bad laws will certainly make worse laws. Moving to the work of the International Affairs Division. The International Affairs Division covers a lot of matters involving public and private international law, matters spanning a wide array of subjects, both on and off the island. Mr. Speaker, time will not permit me to delve into detail, but suffice it to say that before the government of Jamaica signs or accedes to an international treaty, the agreement is sent to the chambers for review. And this is to ensure that there are no impediments to implementing the agreement. This year, we examined a number of environmental matters, the most notable being the Paris Agreement. In reviewing the text, we recommended certain legislative and policy measures that may be considered in implementing the agreement that will demonstrate our commitment to addressing climate change. On the matter of mutual legal assistance, the Chambers has provided and continues to provide advice and engage in consultations on mutual legal assistance and asset recovery in conjunction with various ministries, departments, and agencies. Mr. Speaker, in the area of asset recovery, the Chambers reviews requests for the sharing of assets between Jamaica and other partners, such as the United States and the United Kingdom. Last year, the Sharing of Forfeited Property Act order for the United States of America was passed here in the Parliament, paving the way for asset sharing with the US. Mr. Speaker, in relation to anti-corruption efforts, Jamaica is a party to the Inter-American Convention Against Corruption and the United Nations Convention Against Corruption. The Chambers plays a vital role in providing expertise on Jamaica's implementation of the various provisions of the conventions and Jamaica's anti-corruption initiatives. Representatives of the Chambers, headed by Deputy Solicitor General Dr. Cathy Ann Brown, have been and continue to participate in the review mechanism under both treaties, which include reviewing the actions of other state parties, such as Mexico and Honduras, in following their obligations under the convention. And last year, we were also engaged in the review of Panama pursuant to the UNCAC. The Chambers has provided information for the working group on prevention under the UNCAC and the Committee of Experts under the mechanism for follow-up of the implementation of the Inter-American Convention Against Corruption. Mr. Speaker, the printed copy of this presentation outlines other areas of work by the International Affairs Division. Just to say that the President of the CCJ wrote to CARICOM Attorneys General in March of this year, addressing the concern of the bar and litigants from across the Caribbean on challenges faced in enforcing judgments. This is a topic that the CCJ has taken up. More details are provided in the written presentation. Suffice it to say that the regional obligations that we have undertaken must be implemented and enforced if we are to reap tangible benefits from the CARICOM arrangements. Mr. Speaker, the Commercial Affairs Division. When I last spoke, I mentioned the establishment within the chambers of the Commercial Task Force. I'm pleased to say that we have increased the number of consultants. In fact, we have doubled from 1 to 2, and we also have additional staff. 100%. Mr. Speaker, moving to the Litigation Division. The Litigation Division has had a robust year in the conduct of civil proceedings against the state. I want everyone to know that we took the right decision to settle the Armadale claims. These are the claims brought by the former wards of the state who were housed at the Armadale Correction Center in St. Anne. I'm happy to report that over the last 12 months, we paid out over $18 million in settlement. Mr. Speaker, other matters that the division has dealt with, we have had much success. There are matters that we await the decision of the court, including the Police Federation and the INDICOM, which raises a very important issue of whether the INDICOM has the power to arrest and the power to prosecute. Won't say much more about that because we're awaiting the decision. But Mr. Speaker, we do have challenges in the chambers in spite of the strides made. Our biggest challenge continues to be the volume of work vis-à-vis the limited resources. And we also have difficulty obtaining timely instructions from our clients within government. The Court of Appeal in Homeway Foods and the Commissioner of Lands have indicated very clearly that the state must take full responsibility for the fact that inefficiencies flow from a lack of resources and a heavy workload. And so I'm particularly pleased that the administration has responded so favorably and has made the additional provisions for the chambers. Mr. Speaker, among the many important matters is the Jamaica Bar Association against the Attorney General and the General Legal Counsel. Mr. Speaker, this case involves measures to combat money laundering and counter the financing of terrorism. International standards are contained in the Financial Action Task Force International Standards on Combating Money Laundering and Financing Terrorism, and Jamaica has obligations in this regard. I have set out in details matters relating to that case, but I am inviting all persons in the House to read the decision of the court, notwithstanding that it is on appeal.
Minister, the member's time has expired.
Mr. Speaker, I ask that the member's time be extended by 5 minutes to allow her to complete her presentation.
The motion is that the member's time be extended by 5 minutes for her to complete her presentation. Those in favor? Those against? The ayes have it. Mrs. Fort, you may proceed.
Thank you, Mr. Speaker. And so in the interest of time, I direct everyone's attention to the section in the written presentation about the case. But let me commend the Solicitor General and the team from the chambers who did this matter in court. Mr. Speaker, much noise has been raised about it, alleging that the actions taken were unconstitutional and that the law passed, the subsidiary law passed, was in breach of the Constitution. Well, the Court of First Instance has said that they are constitutional, and we see what happens when the matter is argued in the Court of Appeal. Mr. Speaker, the last area that I really want to address is the vexed question of judgment debt. And I crave your indulgence and the House indulgence to tell you just what we have been doing in this area. Because this is the area where persons have so many problems with the government after they have succeeded in their claims against the government. So at the time of my last presentation to this House in July 2016, I indicated that the amount outstanding as at June 27, 2016 was just over $500 million. 9 months later, the amount remains outstanding as at March 31 is just under $450 million, and that excludes judgment debt interest. Mr. Speaker, at first glance, the figure does not reflect the significant progress which we made in payments out over the period. I had advised the Honourable House on the last occasion of a special submission to Cabinet for additional funds to settle government liability. I am so pleased, Mr. Speaker, to advise that the government responded favourably by providing additional funds in the amount of just over $81 million in the supplementary budget. And I thank the Honourable Minister of Finance for his support and for his understanding of the hardship being faced by so many Jamaicans who are awaiting payment of their judgments debt. It should be noted, however, that for the financial year 16-17, the government had originally allocated a budget of $342 million over towards the payment of judgment debts. At the end of the financial year, the amount of $423,604,000 was received as budgetary support for this expenditure. However, at the end of the month, the amount actually paid towards awards for the financial year was over $426 million. Mr. Speaker, it is a vast improvement. In July of last year, I had also indicated that by the end of July 2016, the Chambers and the Ministry of Justice expected that we would have completed all payments due for 2014. Although the progress seems slow, my information is that at the end of April 2017, the Ministry expects to complete or had commenced making payments due with effect for June 2015. We have narrowed it down significantly. But you know, Mr. Speaker, as much as we are eager to pay out, it has to be recalled that every single week, additional judgments and settlements are added to the obligations of the government. Indeed, as the Minister of Justice has chimed in, it is never ending. But, Mr. Speaker, I assure the people of Jamaica that I will continue to press for additional funds so that we may pay the judgment debts and settlements more quickly. And I have to say a special thank you to the Minister of Justice for his support as we continue to dialogue with the Ministry of Finance for increased allocation. The Honourable Minister and I work very well as a team, Minister. We are extremely sympathetic to the plight of successful litigants who have to wait for extended periods before getting paid. Mr. Speaker, many members of the public do not understand the system in place for the payment of judgment debts. And so, vexed litigants often attend upon the chambers, boisterously, abusively demanding payments. In fact, Mr. Speaker, we have had security concerns at the chambers as a result of this. The Ministry of Justice makes payment for the chambers on our instructions. However, as we know, only limited funds are provided for this purpose on a monthly basis out of the funds allocated for the year. So I ask that note be taken that when judgment is entered
Mr. Speaker, on a point of order, sir.
by the court
Mr. Speaker, on a point
or
of
a
order.
matter is settled,
The member's time for speaking. Mr. Speaker, I am, sir. The member's time for speaking was, it is, Mr. Speaker. It is Mr. Speaker. It is, Mr. Speaker. It has to do with the order of business in this House. Mr. Speaker, I rise because... Mr. Speaker, I rise because of the fundamental issue at hand. Mr. Speaker, Mr. Speaker, when you have set this precedence and I am, or anyone else, any other member of this Honourable House is speaking, it is difficult then, whether or not he or she is on that side or this side, to exercise the gavel. Mr. Speaker.
Okay, Mr. Buchanan, thank you. I hear you. Okay. I hear you, Mr. Buchanan. Mrs. Ford, you are to
conclude.
You must conclude your presentation. Mr. Buchanan is correct. Mrs. Ford, you may conclude your presentation.
Mr. Speaker, I would have concluded in the time that the member spoke. But just to say that I'm sorry, while I understand the point he's making, and I'm grateful for yours and the member's indulgence, just to say, because I think the Speaker didn't want the country to hear, that we have taken steps to improve the system of satisfying judgment debts, so that those who have successfully sued the government will not continue to endure the hardship they have been enduring for so many years. And it is a pity that he doesn't want the people to hear that this administration has significantly In concluding, you see, Mr. Speaker,
And you have incurred a lot of debts.
Mr. Speaker,
You have incurred a lot of the debts.
time certainly does not permit, in the confines of the debate, to tell this Honourable House, including the member from Westmoreland Eastern, who perhaps doesn't want the rest of Jamaica to know all the progress we have made, that, Mr. Speaker, that we are committed, and the Chambers is committed to ensuring that the machinery of government acts legally in the best interest of the people. And so, Mr. Speaker, may God continue to grant us, all of us, the wisdom to discover the right, the will to choose it, and the strength to make it endure. I thank you, Mr. Speaker.
This is my sister.
Order, please. Members, I wish to make a comment to members. When I have before me the presentation that to be made by a member, I use my discretion if you have a page leave. And I wish you to give the Speaker some latitude when there is a page leave, when you give me your presentation, not to cut you off when you have a concluded page.
That is correct.
And if I am wrong, then I will now follow that procedure as presented by Mr. Buchanan. And you will now tell us when to cut them off. But as Speaker, I wish to use my discretion when members are on their last page their concluding presentation, and I wish to do that as Speaker of the House. Next presenter. The next presenter. The next presenter is Mrs. Nita.
Mr. Speaker, I'm grateful to God who sustains me and through whom all things are accomplished. I would like to place on record my gratitude to former Prime Minister, the Most Honourable Portia Simpson Miller, arguably the strongest woman I've ever met in my life, for her years of mentorship and guidance and love, as I welcome and salute Dr. Peter Phillips as leader of this parliamentary opposition. I thank my constituents, the councillors, executive members, and workers in North Central St. Catherine for their continued belief in me and for allowing me to be celebrating my 10th year as their Member of Parliament, along with 9 years at the local government level. I want to commit to them today that you have my unwavering dedication to give of my best on behalf of you at all times. I thank God for my 2 beautiful daughters who have borne the brunt of my commitment to country and party. You are my life, and I love you beyond words. You have made me significantly proud that even after the hard times, you have done so well. Mr. Speaker, during my tenure as Minister with responsibility for sport, I had the honor and privilege to work with some exemplary sport administrators across sporting disciplines. It has come to my attention, Mr. Speaker, that Dr. the Honourable Michael Fennell will demit office as the President of the Jamaica Olympic Association in the next 2 months. I'd like an opportunity to say that Dr. Fennell has given over 4 decades of stellar service to Jamaica and our Olympic movement, the Caribbean and the global Olympic movements, as well as the Games of the Commonwealth. As the president of the Commonwealth Games Federation, he provided exemplary leadership to his colleagues in the apex body and sporting federations. His leadership was not only visionary, but also statesmanlike. He made Jamaica proud, and he made us, the peoples of the Caribbean, proud. I respectfully acknowledge the gentleman with admiration. I hail the length, breadth, height, and depth of the legacy of this patriot. Mr. Speaker, Jamaica's place in the global sporting arena has been well established. Our sportsmen and sportswomen have impacted the world at several levels and in several sporting disciplines for over more than 6 decades. As leaders in this honorable house, we have on numerous occasions taken the time to hail the outstanding contribution that our athletes have made in elevating the stature of our nation on the world stage. As citizens of Jamaica, we have all spent considerable personal time reveling with pride in the unmatched performances of our young people who celebrate our national colors with their remarkable demonstration of sporting prowess at every corner of the globe. The world has recognized our prowess in sports, and other countries, including the advanced economies, who would love today to be the nation whose athlete holds the Guinness World Record for the most sub-10 races in history. Today, we salute Mr. Asafa Powell on this remarkable achievement. Speaker, as we advance our social and economic development, there are important adjustments we will have to make in sport in order to ensure that, 1, we remain competitive and dominant. 2, we access the best investment available to help the next generation of athletes. 3, we continue to improve our involvement at the global level in more sporting discipline. And 4, Mr. Speaker, that we use sport as a tool to fight crime in Jamaica. Mr. Speaker, we have seen the tremendous impact that sport education has had on sports development. The role of GC Foster College and physical education in sport cannot be overstated. Indeed, our tertiary level institutions are expanding their sport programs in recognition of the value of sport education. We must continue to work toward ensuring the development of programs and curriculum that offer all participants in sports the ability to excel in their disciplines and to pursue meaningful careers in sports. I'm being distracted, Mr. Speaker. Mr. Speaker, we must ensure that opportunities in sports management, public relations, course on sport agency, money management in sport, opportunities to become technical support persons like coaches and referees and umpires, managers, physiotherapists specializing in sport, sport journalists, biometric scientists, nutritionists, and all the other sporting disciplines which can assist our sports persons to become the best of the best. And we must pass legislation to help realize these ambitions. I also propose, Mr. Speaker, that the Ministry of Education works closer with the Ministry of Sports to support the development of additional curriculum and subject areas at the secondary level that can be examined at CSEC and CAPE levels for students who wish to develop a career in sport. The option to pursue a career in sport must be as real a career path as it is to study law or to study medical sciences. It must be made mandatory for all students engaged in intense sports training while in high school to have special classes to ensure academic success simultaneously. I urge some of our secondary school administrators to desist from seeing our student athletes as champs machines, only there to score points, but to address their fundamental need as students who must be provided with a rounded education. Mr. Speaker, we initiated the process aimed at developing legislation on safeguarding our children engaged in sport. Minister, please focus and ensure that this does not slip through the cracks. Minister didn't hear, but I want to just ensure that you do. We initiated the process to ensure that there was going to be legislation to safeguard our children in sport. I just want to ensure that you do. Mr. Speaker, in many of our sporting disciplines such as tennis and golf and boxing, basketball, hockey, volleyball, fencing, swimming, pole vault and hammer throw, the national support is still woefully inadequate. History has shown that with the support given to programs and where there's consistent support given to programs and improved disciplines through upgraded facilities, better coaching and more international competitions, our level of success always increases exponentially. But participation, Mr. Speaker, in many of these sporting disciplines is still unreachable for the average Jamaican. The age-old barriers to entry remain. They're too expensive, too focused in one geographical area. If you're not in Kingston, you can't access some things. Or too unsupported by top-level coaches, trainers, and support staff to make participation and ultimately success available to all Jamaicans and not just a few. The youth in Junker Spring, St. Mary must have the same quality access to world-standard facilities as a child in Mona. Mr. Speaker, the national sports policy is premised on the concept of sports for all. This means more opportunities must be provided for participation in these sporting disciplines at the primary, junior secondary, and tertiary levels. It also means more support for the governing bodies to make these opportunities possible. Minister, you need to continue to push for the advancement of a project that is meaningful in ensuring that every child has the access that is required. Mr. Speaker, I want to take the opportunity to congratulate the schools which continue to give and to make investment in their high schools infrastructure through their alumni associations and the foundations. But there continues to be a significant role to be played by the government in undertaking and facilitating these advances. Therefore, we must continue to embrace, Mr. Speaker, that which is important to all of us to ensure the success of sport. I am very pleased to have been a part of the administration which initiated and implemented the Jamaica Athletes Insurance Plan. It has been a game changer for our athletes. After 14 months of its inception, it is clear that this plan has grown in the number of athletes now registered. Mr. Speaker, I have received the many messages of commendation from our athletes, our visually impaired cricketers, and our fast-growing gymnasts who never dreamt this would have been available to them even though they represent Jamaica at the national level. The plan has relieved the burden of costs for physiotherapy, lab works, office visits, prescription drugs, dietitian services. Mr. Speaker, it is with much pride that I stress that all athletes involved in a national sport program, be it jockeys, boxers, swimmers, or Paralympians, are entitled to group health and group life insurance provided by the government of Jamaica. Today, I can say with much relief that I'm happy that I insisted on ensuring that the maternity benefits were retained as part of the plan. I offer my congratulations to those female athletes who have started on their journey to starting a family or in the process of doing so. We look forward to their health return to the track. So, Juliet, we're expecting the member from East Rural to come back. West Rural to come back. Mr. Speaker, our national athletes often compete overseas.
Don't give up, you know.
And under this plan, visits overseas, services received overseas are also covered under this plan and are reimbursable. Many said it couldn't be done, Mr. Speaker, but we proved them wrong. And today we are providing a plan for all national athletes across sporting disciplines, a Jamaica that works for all and not just a few. We must now go further, Mr. Speaker, to suggest to this House that legislation must be introduced to create an Office of National Sports Medicine, headed by a national sports surgeon, to offer medical, nutritional, physiotherapy, sports psychology services to sports persons identified by the same method as was the sports insurance scheme, and to ensure that they receive professional and timely interventions, and in the case of need, like our high school students, that they be cost-free to them. In the grand scheme of things, such an office would, Mr. Speaker, cost the nation very little in relation to the benefits and could also be established to reduce costs with sponsorship and assistance from private sector. Mr. Speaker, our anti-doping program has advanced significantly in Jamaica over the last 4 years. We must never waver on our commitment to focus on preserving the integrity of sport. We must, however, never get to a place where we become the enemy of our clean athletes. Let's continue to educate them. Let's continue to educate them on proper nutrition, as well as their rights and their responsibilities. We need to continue to encourage our athletes to avoid anti-doping rules violations, including the important whereabouts information requirement. I applaud JADCO for its continued work in that area. Mr. Speaker, I implore the government to continue to make JADCO a priority in terms of funding. We will only continue to have a sustainable and credible sports program if we continue to foster a strong anti-doping program. Mr. Speaker, sport in Jamaica is a sector which is far more than most persons would like to admit. It would be easy to say that money for road and money for health and education and crime fighting and a plethora of other crucial activities take precedence over sports. That may be true in general. However, the Planning Institute of Jamaica, in its Economic and Social Survey of Jamaica, has over the years cursorily indicated that the sports sectors contribute up to 3 or 4% of our GDP. Those figures are limited, Mr. Speaker, limited to the system's inability to collect the figures from events, from media, and from other areas of income. This will certainly have to be improved, Mr. Speaker, to empower sport as an economic activity in the Jamaican context. The plan and evaluation going forward must appreciate and value sport as a service sector, sport as an employer, sport as a user of equipment and supplies of high value, sport as having a tangible economic impact, sport as a sector that should be incentivized to attract public-private partnership. There are a number of estimates for the world sport industry's value, and the last one, according to A.T. Kearney, is $648 million US. Now to the value of football here in Jamaica. Our football in Jamaica must aim to do well, to be able to negotiate better investment opportunities for the sports assets. We need to embrace a more sustainable football program. Indeed, we ought to be carefully targeting the 2022 and the 2026 World Cup. Jamaica's ranking in football has been inconsistent, falling in and out of the top 100 nations. This inconsistency, Mr. Speaker, has resulted in our inability to attract significant sponsorship for football, and so the preparation of the national football team is always at risk. Mr. Speaker, globally, football remains the sport with the largest number of global viewers, and it is determined that it is the richest sport in the world. FIFA, despite its recent controversy, has stayed on top of the sport. That in 2010, Forbes estimated the World Cup in South Africa to have yielded some $147 million US, and has indicated that the event really only attracted about 3 million viewers. A significant investment is needed in the grassroots program right here in Jamaica. We must be able to sustain the development of these youngsters by investing in a development program that keeps them in training all year round. We need to develop a cohesive team of properly trained professionals who are homegrown, homeschooled, and home-trained. I won't be liked much for saying this, but Mr. Speaker, it is ill-conceived to keep relying on overseas players at the last minute to come in to rescue our football program. The truth is, Mr. Speaker, that while I appreciate the efforts of the Federation, I am still struggling to see the growth in football over the last 20 years since we qualified for the 1998 World Cup. I am struggling. I don't know if anybody else is. And there is no doubt that we have the talent here in Jamaica. Let us develop the program that is needed to expose this talent. While government cannot fund and plan every single body, I believe that the investment in football is critical because of the returns that can be for our people. It is necessary that we lead the way as government in creating proper football fields. I'm ashamed on a premiere night to look and see the fields that our youths are playing on. It's important that these are zoned across the island to effectively develop talent. Additionally, where we suffer from drought, where we suffer from too much rain, where we suffer from lack of maintenance, let us put in some astroturfs to ensure that our children constantly have access to quality facilities. So, Speaker, while I implore our sporting federations to use their disbursement from the SDF wisely, it is clear that the funding available for development of sport in Jamaica is woefully inadequate. Although the Chase Funds currently places sport as the #1 beneficiary of the fund, considering that the sports sector does not have its own ministry, does not have its own budget, it is important that we recognize that there must be increased funding to sport. I'm humbly imploring the Minister to join with me in calling for an improved and increased allocation to sport, moving from the 40% to at least 50% of the funds derived from the lottery funds at this time. Let's stop talking and playing lip service to this need. Let us get to doing what is required in order to continue to advance our place in sport. Mr. Speaker, for many ordinary Jamaicans, engaging in sport is fun. For some of us, it is healthy living. And for others, it's a way of escaping and ensuring that we get away from the conflict at home and the homelessness sometimes and gang violence or temptations to use alcohol and drugs. By wearing a team uniform, I can tell you my own constituency, it makes a difference. Young people feel equal once they put on a uniform. They feel like they belong somewhere, no matter how diverse the backgrounds. When they put on that uniform, they're a part of a team. Sport and physical activity can give people a sense of belonging, a sense of loyalty, a sense of value and support, which may mean that suicide and truancy and illicit drugs use are no longer viewed as options. Sport and physical activity can have long-term benefits in the social development of young people. It may also have an immediate benefit that coincides with the duration of the sporting activity. During the World Cup, there was no crime committed during that match right here in Jamaica. For hours, no matter how long the sporting event lasts. During the Olympics, we have less crime as well. So, Mr. Speaker, indeed, reported levels of assault, malicious damage, receiving or selling stolen goods, lot of scamming, breaking into homes, businesses, and even churches, something that didn't happen when I was a child, or motor vehicle theft, is something that we can use sport to stem. Crime prevention strategies are usually characterized by 3 ingredients: a motivated offender, a suitable target, and an absence of a capable guardian. This is by Cohen and Felsen. For peace policy implementation in Jamaica, we must seek to attain these 3 objectives: to reduce the supply of motivated offenders. And we will do so, Mr. Speaker, because devil find work for idle hands. And if you're idle and you're not doing anything and you're not a part of anything meaningful, somebody will recruit you. Yes. To make crime more difficult to commit, and to ensure that we create structures that increase the supervision of possible offenders. Where the supervision is not provided by home or school, I can tell you many times, young students listen to their coaches and their team captains even more than they listen to their parents. So, it is important that we note that our Minister of National Security, who is not here today, I wanted to tell him that forget the obia, try sports. It works. Let us develop crime prevention through structured, targeted, and focused programs, including sports from childhood.
Juliet agrees.
Urgent steps must be taken to engage marginalized youth, or they will continue to be easy prey for those who would lure them into criminal activity. and community crime prevention as I watch Arnett and Tivoli play in a match in the same friendly space, in a structured sports program. It is clear to me that sport is the greatest unifier there is. Mr. Speaker, I wish to challenge the members of this Honourable House that we must continue to embark on programs that promote participation, inclusion, human values, acceptance of rules, discipline, health promotion, non-violence, tolerance, gender equality, and teamwork as we take meaningful steps to counteract our current crime situation. The social need for sport is just as important, and we must unite and ensure that all the ministries which have value towards social need come together. While we recognize and applaud the hard work and dedication of our athletes, we must ensure in this House that they too can be proud to carry our flag wherever they go and stand poised for the playing of the national anthem. They can't be ashamed to be Jamaican when they stand on a podium. As lawmakers, we owe it to them and to ourselves. Mr. Speaker, in conclusion, let us not be complacent and revel in the glamour of our success. Let us not be caught napping as we bask in the glory of winning. Let us instead work together to provide the governance required to renew our passion to make not just track and field, not just football, cricket, or netball, but all Jamaican sport, make them world beaters. Our tourism product will improve. Brand Jamaica will improve. Our global stature will improve. And the national fervor for a better Jamaica that works for all Jamaicans and not just a few will be visible. Finally, Mr. Speaker, allow me to remind this Honourable House of the words of the great Nelson Mandela, who said, "Sport has the power to change the world. It has the power to inspire. It has the power to unite people in a way that very little else does. It speaks to youth in a language they understand. Sport can create hope where once there was only despair." Thank you very much. Thank you.
Mr. Speaker, I ask that the sectoral debate be suspended until Tuesday, May 30th.
Thank you very much. Thank you.
The motion is that the debate be suspended until next week.
Mr. Speaker, what I said, I asked for this sectoral debate to be suspended until the 30th of May. Tuesday, the 30th of May.
Thank you, Mr. Minister. Those in favour for the debate to be suspended until the 30th of May. Those in favour? Aye. Those against? Ayes have it.
Mr. Speaker, the Minister of State for Education, Youth and Information will take item 9 on government business. The resolution.
Minister Green. Those in favour? Aye. Those against? Ayes have it.
Mr. Speaker, is not intended to do any further business for today, so I ask that the House be adjourned until Tuesday, May 30th at 2 p.m.
Resolution is that the House be now adjourned until the 30th of May. Those in favour? Aye. Those against? The ayes have it. This Honourable House now stands adjourned.